Ladies and gentlemen, welcome back to the People's Law School. This is a program by the Alabama Trial Lawyers, the Alabama Association for Justice. We reach 2 million people all over Alabama. And I want you to know, as a trial lawyer, I've been doing it about 40 years, and our next speaker, I tell you, we bring the best speakers in America, and we do. Jim Richardson, our next speaker, is one of them. And I want to tell you a little bit about him because I've known him a long time. He's usually been my adversary. We've been together on a couple of cases over the last few decades, but the Chief Justice of the Supreme Court said this. He said the highest reward that can come to any lawyer, that's because nobody really knows what we do, because it's kind of a mystic goodies type profession. The highest reward is the esteem that of his professional colleagues, his fellow lawyers. And that esteem is won in very unique conditions. Let me mention to you that law school is not hard. The material is not, but they make it hard because we are under so much stress. And what they really want to do is see those who can and can't take it. That's the way I figure. And in reading this article by the Supreme Court Justice, he says this esteem that one lawyer has for another, his adversaries, is unusual because it cannot be purchased, it cannot be created artificially, and cannot be earned by contrivance, but it is earned by having the integrity, the brains and skill and honor in a performance that is just unbelievable. When we talk about people that are charged with homicide or are involved in murder cases or abortion cases or divorce cases or custody of children cases, the pain and suffering and the stress of our clients just automatically goes to us, and it's a nightmare. I want you to know. Carrie Riley, one of our speakers later, will tell you that she says that the practice of law is just a state of controlled panic, and so we have to do that. But when I read this, and the Chief Justice goes on and he finishes by saying, but the lawyers are the officers of the court, and it is through the honor and integrity that we have. And I mention that because a lot of lawyers are making a joke of the law on billboards and everything else now, and it really embarrasses me. But I tell you, we see it, the ones who are really in the courtroom, and they are people like Jim Richardson. And what the Chief Justice said is that it is the honor and integrity of the lawyers that keep our society together. We also see this, by the way, in countries like Pakistan that are almost ready to fall apart, but their legal system is so good because it's copied after England that, in fact, their judiciary and the lawyers of that country are, in fact, keeping a state of chaos relatively under control. Now, I mention that because when I read this a while back, I thought of Jim Richardson. Because I've been through the war with Jim, and he's seldom been on my side, and he's driven me nuts every time I had a case against him. And I tell you that, in all seriousness, he has practiced law in every case with honor and integrity, and I admire him a lot. Now, he practices law with the firm of Richardson and Maples. He's a fifth-generation lawyer, graduate of Randolph School, Indian Springs, Davidson. Those are silver spoon schools, by the way, in case you're wondering. By the time you're a fifth-generation lawyer, I guess you begin to think like that. As a first-generation lawyer, I will tell you some lawyers I think that are losing their mind. I said, you're beginning to remind me of one of the Richardsons or the Fords or the Laniers. And they don't think that's funny, the Richardsons or the Fords or Laniers. But I said, you've forgotten how the other people think in regard to what the law system is about. I teasingly say that to the Richardsons, but all of them are the best, and they're all excellent lawyers. And his brother's a judge, by the way. A lot of folks know Dick Richardson, and as was his grandfather. The courtroom, the main courtroom in Huntsville, is named after his grandfather. It's the Schuyler Richardson courtroom, by the way. Now, having said that, Jim clerked for the U.S. District Judge in the federal system, and he was specialized in insurance defense for about 20 years, and then about 10 years ago or so, he fired all of his insurance companies and decided that he would, I want to say, return to the people, take care of his own folks, those that he grew up with, and that's who he's trying to help. So it is with great pleasure and that I mention to you, and it is my honor to present to you tonight, Jim Richardson. Thank you for coming, my friend.
Thank you, Alan. Always a pleasure. Alan and I have had some wars, and if anyone actually embodies the concept of controlled chaos in the courtroom, it would be Alan Brinkley. And he's kind of like the Tasmanian devil of litigation. You never know what's going to happen, but it's going to be fierce. I appreciate the chance to come back tonight and speak to some old friends and hopefully some new friends about the subject that I learned a lot about over the years, which is insurance law. I guess what I can call myself now is I am a recovering insurance defense lawyer. Insurance is an area that is boring to a lot of people. There are a lot of lawyers who would just as soon cut that class or skip that course. And what we've found over the years is that, those are going to work to your disadvantage ultimately if you really don't know what the ins and outs are in the insurance world. They're going to run over you if they can. Insurance companies, we tell our clients that insurance companies have no feelings. They don't have a heart or a soul. They have a calculator. And insurance companies are all about the distribution and the management of risk. They sell policies, they collect premium, they invest that premium, and hopefully they make a gross profit. But the way they really make their money is to pay as little as they can on the claim side. So the claims costs and ultimately the defense costs are where they put the most pressure. And if they can control those liabilities and pay policyholders or third parties as little as possible, if they can pay their own lawyers as little as possible, then that contributes to the bottom line. And unfortunately, that is the climate that you deal with when you have an insurance claim. You look around at TV and you're going to see a lot of this, and during the NCAAs, you'll see the Mayhem guy from Allstate, or you'll see the guy who was the president in the old series 24 Hours. You'll see the lady in the Progressive ad. You'll see the lizard in the Geico ad. And they all look trustworthy and they all look cute, and they do that for a reason. Because insurance companies really are neither trustworthy nor cute. They're out there even today contributing heavily to the political climate, which has made the court system extremely adversarial, extremely pro-business, and very anti-victim. So when you're in a situation where you have an insurance claim, or even when you're thinking about your own insurance policy and what your coverages are, or maybe what they should be, you can't take anything for granted. You have to know what's in your policy, and you really need to talk to a lawyer if you have any kind of question about your insurance. And certainly if you have a claim, the last thing you should try to do is handle it yourself. As we say sometimes, don't take a knife to a gunfight. Insurance professionals are trained and they handle hundreds of files just like yours, and you may have one or two in your lifetime. They feed on the ignorance of the masses. And it's to no one's benefit but the insurance company to try to handle a claim without professional advice. You wouldn't pull your own teeth, you wouldn't take out your own appendix. You shouldn't try to handle your own insurance claim. I'm going to talk tonight about several different types of insurance that we typically need to consider, and I'm going to try and give you some examples of some problems that we see in our practice. Jacob and I do almost exclusively insurance-related claims, whether it's workers' compensation type claims, which he will talk about, or automobile accident claims, homeowners claims, premises liability claims. Insurance pretty much drives the litigation field, and so we are involved in the insurance world every day. Almost without fail, the first question that we will ask a new client is, what kind of coverage did you have? And I would say at least 95% of the time we're told full coverage. And almost without fail, when I ask the next question, what does that mean? They can't tell me. It's what the insurance agent made them think they had. Unfortunately, what the insurance agent tells you, if it's different from what's in the policy, isn't going to help you get that claim paid. Full coverage has no meaning as a matter of law. Your coverages are dictated by what you buy, and they're all spelled out on what's called the declarations page. And you may think you have full coverage and find out that you really have anything but full coverage. What you're required to have as a matter of law in the state of Alabama for an automobile or any motor vehicle is liability insurance. That is mandatory. You would be surprised probably to know that roughly 20 to 25% of the people in this state still don't have their mandatory liability insurance. They either never got it, or they let it lapse immediately after they got the car, or had their license renewed, or got their tag renewed. And we see that all the time. The statistics run about 24% of the motorists in the state of Alabama are purely uninsured at any given time. So, notwithstanding the fact that these insurance requirements are mandatory, there's a lot of folks who will not obey that requirement. The minimum limits that you have to have on a liability policy are only $25,000 for any one victim and $25,000 for all victims of the same wreck, no matter how many people were in the car. 10 people in the car, $50,000. So it is a serious question whether minimum limits are in fact adequate at any given time. Also mandatory, under the law at least, is uninsured motorist coverage. As a matter of law in Alabama, uninsured motorist coverage is the same as underinsured motorist coverage. If someone hits you who has no insurance, they are uninsured. And there are many definitions of an uninsured motorist, like a phantom motorist, somebody who runs you off the road, doesn't even have to hit you, but a hit and run type incident where that driver is never identified, that is by law an uninsured motorist. There are cases out there that say, well, if a seat falls out of a vehicle and it's on the road and you hit it, well, it had to have come from a vehicle which is nowhere to be found, so it has to be an uninsured motorist claim. So there's some interesting wrinkles, but the question is really that we see every day is what is the other side of the uninsured motorist coin? Uninsured motorist is also underinsured motorist. The same coverage is there if the person who hits you does not have enough coverage. The minimum limits, the same numbers apply, $25,000, $50,000. So one person is hurt, you have $25,000 worth of uninsured motorist, or all people, $50,000. And that rides with the car, so that if you're a passenger in someone's vehicle and you have cars at home, you have the option of stacking your coverages, which your attorney should be able to explain to you, allow you to mount these coverages up and give you a higher aggregate total. The biggest problem that we see is with clients who come in and for some reason they have been persuaded to drop their uninsured motorist coverage. Now, some people do it for economic reasons and they can only afford the mandatory liability. And I sympathize with those folks, but typically they're coming in without enough resources to pay the doctor or to handle their own medical bills. The difference in premium to add the uninsured motorist coverage is not very high, certainly when you're talking about minimum limits. And actually, as a marginal cost, the cost of adding uninsured motorist coverage is not appreciably higher than your liability coverage. It's actually lower. The highest cost in your car insurance is going to be your collision, because they know that you're going to have dents and you're going to want to get them fixed. You might not have an accident involving injuries. Under the law, uninsured motorist coverage is mandatory, but it can be declined or disclaimed. And if an insurance agent persuades a client to decline uninsured motorist coverage, they have to get that in writing, and it has to be signed by the policyholder. The policyholder, it could be the husband on a jointly owned car, and they can disclaim coverage for both husband and wife. Unfortunately, the law allows the insurance company to never offer uninsured motorist coverage again. I represented a lady one time who came in when she was in her mid-30s. She was in a bad wreck with a lady who had $25,000 in the mandatory minimum limits. This lady had a very complicated injury to her leg, and it took her months to regain her ability to walk. Her medical bills were in the deep six figures. All she could ever get for that accident, which was in no way her fault, was $25,000. Because when she was 21 years old, some enterprising insurance agent had gotten her confidence and had persuaded her to disclaim uninsured motorist. Since that time, she had gotten married, she had had 2 children, she had bought and sold a number of cars, but they never offered and never put uninsured motorist coverage on her policy again. And more than 10 years later, despite all those changes in circumstances, that stuck. And that's what she was left with. By contrast, we've had a client recently who was a passenger in a vehicle owned by his company. They were in a serious accident, and he was in long-term medical care for a number of years. His medical bills ran into the hundreds of thousands of dollars. He was able to stack the $500,000 policy that covered the vehicle under the fleet policy with 3 policies he had at home that each had $100,000 worth of uninsured motorist. So the coverages that were available to him were $800,000, 32 times what was available to the lady who had relatively similar injuries. Obviously, you have to do what you have to do from a financial standpoint, but make a decision to drop uninsured motorist coverage very, very slowly. I would advise anyone to maintain uninsured motorist coverage, even if you have to reduce your liability limits, because 1/4 of the people out there have no coverage, and the ones who do have coverage, a large percentage of them have minimum limits. Nowadays, we see people coming out of the emergency room with bills in the range of $25,000. So minimum limits really are minimal. One of the other coverages that you can buy, which you should consider, would be medical payments coverage. This is a type of health insurance, but it is not a substitute for your health insurance. It is a supplement for your health insurance. The purpose of medical payments coverage is to pay bills that you incur for the treatment of injuries that you sustain while operating or occupying an insured vehicle. That's basically the definition. What we counsel our clients to use that money for is to pay deductibles, co-pays, or to pay for the kind of services that are limited under your health insurance, like physical therapy, chiropractic care, the types of things that insurance companies may flinch about or may limit their benefits on. But medical payments coverage is the coverage that should be used to fill in the gaps with your health insurance. Unfortunately, most folks really don't understand the priority of their insurance, and I'll get into that a little bit later, but your medical payments coverage is now being looked at as fair game by the hospitals and the other medical providers because there's no coordination of benefits and there's no negotiated rates that attach to medical payments coverage. So, as an example, we represented a young lady who was injured in an accident. Her sister was driving. They were run off the road by a phantom motorist who kept on driving. And this young lady had her spleen ruptured, and she was able to recover, but this is a minor, a young lady about 13 years old. Her parents had health insurance. They went to Huntsville Hospital. The mom told them what the policy number was. They never submitted a claim to the health insurance, and instead they put a lien on the young lady after they had attached all of the medical payments coverage that was on the car. The reason for that is obvious. They could get the $5,000 in medical payments coverage that the parents had on the vehicle, and then they could hope to get more without having to take the negotiated rates that Blue Cross or Aetna or United Healthcare have hammered down. So there's a profit motive on the part of the hospitals and in the medical community to try to use medical payments coverage and to try to focus on the claim as a source of insurance when in fact they should be taking by contract the health insurance. If you have a contract that most people do with Blue Cross, it's the majority insurer. Huntsville Hospital, for example, has to take it. Blue Cross takes the position that it is mandatory for providers in network to take that coverage, but they will do their best not to do that in order to make the higher recovery on the services that they can get under medical payments coverage or perhaps by attaching a liability claim for a third-party insurer. I'm going to talk a bit about the kinds of non-automotive type insurance. I mean, if you have a home or you rent a home, you need to have homeowners insurance. Most banks and mortgage companies require that. It's pretty customary. Some of the things that we frequently see are the differences between replacement cost and actual cash value coverage. If you don't have replacement cost coverage, then the insurance company only owes you the fair market value of the item in its depreciated condition immediately before the loss, say right before the fire. If you have replacement cost coverage, they owe you the difference between that depreciated value and what it costs you to replace it, subject to the limit on your coverage. But the gotcha there is that you have to advance the difference. So if you have, let's say, a $1,000 item and it's now worth $750, and you make a claim for it, say it's burned up in a fire, the insurance company will typically pay you $750 even if you have replacement costs, and it's up to you to come up with the other $250 to buy that item and then get reimbursed the difference from your insurance company. That's the way replacement cost works. It's on your back to basically advance the cost in order to get reimbursed by the insurance company. There are a number of coverages that are typical in the average homeowner's policy, and nowadays, we see a lot in the news about cyberbullying and media attention, and one of the little-known aspects of homeowners insurance is a liability coverage called publication. In the old days, that would cover you if you were sued for slander. Nowadays, the purpose is best served if, for example, you posted something on your Facebook page or somebody was getting after your child for some sort of slander, in effect, some defamation. That's what that coverage is for. It's for defamation. Part and parcel of your homeowner's insurance, if you live in a flood zone or in an area that could be a flood zone, depending on how new the flood zone map is, you need to consider getting flood insurance. Now that's really offered through the federal government, but your agent, your insurance agent, is the source, the marketing source for that. That is the only source of coverage for a flood. If you have a pipe burst or that sort of thing, that would be covered under a different type of coverage. But if the Aldridge Creek homeowners, if anybody here remember the Aldridge Creek flood, if any of those folks had flood insurance, they were covered. If they didn't, they did not. So it makes the difference between having coverage for a loss caused by a true flood or not having coverage at all. There are a number of cases out there right now. One of the areas about homeowners coverage is you will see mold typically is excluded. If you read your exclusions, they will not cover you for mold. Some policies, and I've seen this in USAA policies, will pay a certain amount of money to clean up mold, but they will not pay for liability and they will not pay for property damage occasioned by mold. Yet we have more and more of these problems every day. We were involved in a case that's in trial, was in trial all last week and into today, that dealt with a $500,000 liability claim arising out of a renovation job at a local office building. Our client was a general contractor. It was a $40,000 job. Our client's coverage was denied from the outset, and actually that worked to his benefit because we were able to explain that to the plaintiff's lawyers, and we were able to negotiate a resolution for our client premised on the fact that he didn't have any insurance. So it actually, in a roundabout way, worked to his benefit. But if you are shopping for insurance and you have any issues with respect to mold or concerns for mold, you need to take those up with your agent. There are some special endorsements out there with certain companies that will provide you with some coverage, like the USA policy, which is better than nothing, which is what our client got in that renovation job. Other considerations in the market, if you rent, and a lot of people do, particularly if you move around, you may be renting instead of owning or renting between homes. You need to have renter's insurance. It's the only way that you can get the liability coverages that you would get with a homeowner's policy. And in fact, this is a requirement we've learned for Army personnel who are stationed overseas, that they have renter's insurance to cover for, basically it's a stopgap coverage. If you are in a high-profile occupation, say a target like a lawyer in a liability case, or if your lifestyle or your business requires you to take on exposure like a lot of driving, or if you have boats, if you have teenagers who are driving, and you have some assets that you're concerned about protecting, you should consider getting an umbrella policy. An umbrella policy adds a layer of liability coverage on top of your basic liability coverage on your homeowners and your car insurance. If you are looking for the best coverage you can get, you should be looking for coverage that will give you uninsured motorist benefits that are coextensive to your umbrella. That way you are insuring yourself and your family to the same extent that you are insuring the world in the event of some kind of accident or disaster. Jacob is going to talk to you about workers' comp, and that's an area that is insured, and he knows more about workers' comp than anybody I know, and I'm not going to steal his thunder, but there is an area there where people forget that they should be insured. You have to opt to be covered. You have to elect to be covered if you are an owner, like a partner or a principal in a company. We currently represent a gentleman who was an HVAC contractor. He was an owner in the business. He was injured on the job working for a nice couple, but under circumstances where he may or may not have a good premises liability case. Had he elected workers' compensation coverage, he would have at least had disability payments and he would have had his medical bills paid. So consider whether you qualify for workers' compensation at your job or at your place of employment. There are a number of other types of insurance, and time doesn't permit to cover everything, but when you're considering insurance, you're basically dealing with your own insurance company or you're dealing with somebody else's insurance company. So let's talk about what you should do in the first instance, what we call a first party context, where you are the policyholder or you want to buy insurance. The first thing I would say is if you have a complicated insurance issue, you should get some legal advice to begin with. You can rely to a certain extent on the advice of your agent. Good agents are excellent at giving this advice, but unfortunately, not every agent is an excellent agent. We tend to advise our clients to get coverages based on the risks that they present to us and that we understand in their business or in their personal lives. When you go without explanation to an insurance agent, you don't typically know the right questions to ask. So what we tend to encourage folks to do is to ask the agent, what is the coverage that you recommend for me? Make the agent have to come out, draw the agent out, make the agent recommend coverages to you. You know, what would you recommend for someone with 2 cars and a teenager at home who's about to be a driver? You know, get that advice from your agent and take notes when you're talking with them and keep those notes because you may need them later. But make the agent take responsibility for helping you select the coverage. When you do get advice from your agent, it is a contract. If he says, I'm going to get you a policy that will cover you for this risk, and he doesn't do that, that is breach of an agreement. So you at least have some security in case that representation, that agreement falls through. If the agent chooses poorly, the agent can be liable in negligence for basically failing to use reasonable care, professional care under the circumstances. And if the agent misrepresents the policy completely, there could be liability for fraud. But ultimately, you want to be covered. All those claims against the agent don't substitute for having adequate coverage when you need it. 3 horror stories that we've dealt with. We had a client who had a very esoteric line of business. This client had a specific risk, and he spent days with the agent explaining the risk, showing them what they did. The agent promised this coverage would be there. He delivered a big, thick notebook of stuff. And the first claim ever made against this company, the insurance company denied. And we wound up defending the claim. We were fortunate in our ability to get it resolved relatively reasonably. But what that left the client with is a lawsuit against the agent and the insurance company. Unfortunately, in this very pro-business climate that we have developed politically, our court system tends to side with the insurance company and with the agent. Once upon a time, when I started practicing law, a policyholder could simply say, I couldn't understand the policy. Now, the appellate court charges every policyholder who can read the English language with understanding what's in the policy. So the shift has been made against a claim for negligence in favor of the policyholder and against the agent, and really in favor of the agent because every policyholder is chargeable with knowing what they bought. Therefore, they willingly accepted this product, whether they knew it or not. As an example of that, another of our clients is involved in a pretty complicated business arrangement, and they have multiple layers of insurance, insuring equipment in transit, insuring sensitive equipment being used to render services, insuring a fleet of vehicles, and they have another notebook full of insurance that's delivered to them by their agent. This company suffered an event that turned into initially about $150,000 loss, which they assumed was a bad performance on their part. They did not know at the time that there was an equipment failure that was involved. They also did not know that buried in their insurance policy, which had never been explained to them by their agent, there was coverage for liability for claims like that. They proceeded, as reasonable businessmen and women will do, and they resolved their difference with their business partners in a voluntary manner, then learned they had insurance to cover it, but by that time it was too late and they had no claim. So the money that they had agreed to pay to compensate their business partner for the failure, which could have been covered under their insurance policy, they simply paid out of pocket, and they had no compensation, even though they were paying premiums that would have covered for that. The issue that confronts many of our clients after they have bought their insurance and they're involved in a loss. Let's say they buy a standard automobile insurance policy and they buy $50,000 and $100,000 worth of coverage, $50 for one person, $100 for everybody in the vehicle. Well, that seems like a lot, seems plenty in the average situation. But let's say this is a horrendous wreck and there's hundreds of thousands of dollars worth of medical expense. And this person with the insurance has assets and has a job and really is now concerned about their personal exposure. We get asked to look at those kind of situations frequently. That is what we call excess liability, where the policyholder is confronting liability that exceeds the coverage afforded under the policy. That there are a certain number of things that your attorney can do for you to protect you even when you might not have enough insurance. Frequently, you can obtain an agreement to settle and release the policyholder for the payment of policy limits. Not very many people these days want to take somebody's home or garnish their wages if they can collect from the insurance company without a lot of excess work and effort. So as an attorney for a policyholder, what we're frequently asked to do is to deal with that, and we send out what we sometimes call the do right letter to the insurance company or its agent, telling them to do right by the policyholder and settle the claim within the policy limits. Once that is done, that typically shifts the burden to the insurance company. They then have a duty to get that claim settled if it can reasonably be settled within policy limits. And if there's an excess verdict, an excess judgment, and it goes beyond the policy limits, the policyholder can then turn to the insurance company and force them through litigation to pay the excess. Another first-party claim issue that we deal with quite a bit, and it's a third-party claim issue also, is subrogation. Buried in every insurance policy that I've ever seen is the right of the right hand to taketh away what the left hand may have giveth under the policy. Insurance companies demand a right of reimbursement, and logically it makes some sense. If you are entitled to compensation because someone did something to you, you shouldn't have been hurt. They shouldn't have had to pay your medical expenses for being hurt. That makes sense to a certain point. What we see is insurance companies try to use that to control the process quite a bit, and particularly in underinsured motorist cases where the insurance company for the liability carrier, let's say you're in a wreck with the lady down the street and she has Alpha and they have $25,000 worth of coverage and you have a $50,000 claim, and let's say you have State Farm. Well, you might reach a settlement with Alpha for the $25,000 and you would let the lady go, but your good neighbors at State Farm have 30 days to decide whether to approve your prospective settlement and allow you to resolve that claim with the nice lady down the street. They also have the right to advance that $25,000 and force you to proceed against the nice lady down the street, who by this point in time has become a puppet on the string of another insurance company that she has nothing to do with. And the Alpha retained lawyers have to defend the case. So uninsured motorist coverages and the carriers that are selling those coverages try to use subrogation as a tool to resist agreeing to a settlement, because they have a right to recover. If they pay you, then they could go after the nice lady down the street to get reimbursed, which almost never happens. But they use that as a way to keep an individual defendant in a case rather than have you suing State Farm in a direct action, because to my experience, almost no one on a jury who doesn't work for a company like State Farm gives a rip about what will happen to State Farm. State Farm knows that, and they're trying very hard to avoid being put in the crosshairs of a jury with the opportunity to return a verdict against the insurance company. One of the biggest problems we run into, though, in the subrogation area is where you are a policyholder in a health insurance program that is provided by your employer, not one where you are paying the premiums out of pocket in a group purchase situation, but where the employer funds the insurance company, or at least some of it. Those policies are what we call employee welfare benefit plans, and under those policies, they are protected by a federal statute that's generally called ERISA, the Employee Retirement Income Security Act of 1974, which gives the insurance companies absolute reign over the policyholders. And we have seen cases where someone may be in an accident, seriously hurt, and incur substantial medical expenses. Their group health policy may pay those expenses, and then the group health carrier has paid more than the liability insurance and the uninsured motorist insurance all combined. Under ERISA, they can take everything and leave the victim with nothing. Now, unfortunately, there is no leverage for that, because ERISA is a federal law and it's a federal question, and the cases are pretty clear that right is enforced in federal court. Now, I have to dance around. There's a good bit in the handout that I would encourage you to read if you're staying up late and need something to put you to sleep. But let me talk a little bit about what we tell our clients to do when they're in a situation where they think they might be sued. Let's say, the neighbor's been visiting and they fell on the porch going back to their home, or your daughter was in a car wreck and it was her fault. What should you do? What should your family do? The first thing we tell people is always be careful in the way you act and the way you talk. You want to maintain as much as you can a level disposition. You don't want to get panicked. You don't want ever to admit that you were at fault. And you don't want to be confrontational. You want to be civil. You want to be courteous. What we find is that the folks who actually will call and inquire about the health of the accident victim are looked at in a much more gentle way by the victim than the folks who ignore them. So you want to be civil and you want to be caring, but you can't admit fault or responsibility. If you are asked to give a statement, you should always decline. Give no recorded statements. If someone gets you on the phone, they want to take a statement, you've got something else to do, sorry, you'll have to call them back, and then lose the number. If you are in a situation where you think something is going to happen like I described, somebody has been hurt or there's been an accident, you need to notify your insurance agent right away. Don't let time slip by because you have an obligation to report a potential claim in a timely fashion. Consult with your attorney as quickly as you can to try to evaluate whether you have issues that need to be addressed by your attorney. If you're in an accident situation, we always tell people, you've got a phone in your camera in your cell phone. Pull it out and take lots of pictures. If you get in an accident, get the accident report, get all the documents that you can, preserve those documents, don't write on them, hold them safe, and get them to your lawyer. If in fact you are sued, and that's a fact of life these days, everybody may be sued at some point in time, you're going to have some duties under your policy of insurance, and you have to comply with the contract. These are called generally duties after loss. You have to give prompt notice to your agent, again, or to someone else as your agent may dictate, like a claims office, of the receipt of the suit. Do not attempt to dodge service. So you can be served by publication and not even know it. You will have certain requests put on you by your insurance company, and you should cooperate with them. If you're being sued and your insurance company wants to take a statement, then you're going to have to give them a statement. But I would recommend that you get your lawyer and make sure that the statement that you're giving is something that's being monitored by someone who's knowledgeable on your side. If you are sued for more money than you have coverage for, or if it's a suit for an indeterminate amount of money, which is frankly more common than not these days, consider talking to your own lawyer. Too many times these days we see lawyers hired by insurance companies, not indirectly like I was in the old days. My firm was of counsel to a number of insurance companies, and we would be hired on a case-by-case basis, but we maintained our independent existence. Nowadays, many insurance companies have in-house lawyers. Those people work for the insurance company, and their loyalties are clearly aligned with the insurance company and not necessarily with the policyholder. And we're engaged in a number of cases now where the conduct of those in-house lawyers is at best questionable. So if you're being defended by an in-house lawyer working for Allstate or Nationwide, then you probably have more concern than the average person should I get outside counsel. And certainly if you're sued for an excess amount, you need that do right letter to go to the insurance company as quickly as possible. The same advice pretty much holds if you are making a claim. If you're in a car wreck, for example, make sure you can document where you are. Take pictures of the cars, take pictures of the scene. By all means, if someone comes up and says, I saw it all, get their name and number. I was just talking to somebody last week who had 3 witnesses whose names that she didn't know. And, that sounded good, but it doesn't help very much. Say as little as possible on the accident scene. Don't ever say you're okay because you don't know you're okay. If you're my age, in 2 or 3 days, you're not going to feel so hot. And back injuries and neck injuries in particular are known to accrue over a period of 2 or 3 days. So be very careful before you say, oh, I'm okay. That may or may not be true. Again, you may have a claim on your own insurance, even though somebody else is at fault. You may have that uninsured or underinsured issue, so report the occurrence to your own agent as soon as possible. If you are hurt or have any doubt whether you're okay, go as promptly as possible to the hospital or to your doctor. Delayed treatment only raises questions that the insurance companies feed off of. When you're talking with your doctor or any healthcare provider, give a very consistent history. I was doing okay. I mean, most everybody at my age has had a back problem or some other problem. You know, my knee hurts. But if I'm in a wreck tonight and my knee is worse, I'm still entitled to compensation. So what I would need to tell the doctors is, you know, I've had some knee pain in the past, but I've been doing okay until I had this wreck. And I need to give that history consistently to every provider that I see. Don't leave a gap, and don't leave it to their recollection perchance months from now if they're called upon to say, well, what was it that Mr. Jones said, you know, after he came to see you? When you go to the hospital or the doctor, don't tell them that you have a lawyer. It's confidential and privileged if you have a lawyer. It's none of their business if you have a lawyer. If you're asked that question, leave it blank. They have no legitimate reason to know that. When your lawyer wants their records, your lawyer will contact them. Unfortunately, many doctors are trained by the medical liability insurance company called Professional Assurance to be very phobic of lawyers and the legal system. And they will not treat patients with the same degree of care who have a lawyer that they will those who don't say they have a lawyer. And do everything the doctor says. Try to get well. That's what it's all about in the final analysis anyway, but don't skip appointments. It'll make the defense lawyers will make that look like, well, you must be okay, or you would have been at the doctor's office. One of the biggest problems that we see in terms of insurance is clients who don't understand this. You cannot make the other guy pay your medical bills. Workers' comp is the only area that I can think of where the other guy, the employer, is responsible for the employee's medical treatment. But even in that context, it's not a good situation because the employer then gets to dictate who the doctor is and what the treatments are, and Jacob can go on and on about that. But in the liability insurance context, their obligation is to pay you reasonable compensation for your injuries, which could include the reasonable cost of your medical expenses, as well as your loss of wages, as well as any permanent impairment or disability, and pain and suffering. So ultimately, you will recover if you have a claim of liability and there is the ability to pay, but they will not, on an interim basis, pay your medical expenses. That's why you have health insurance. So when you are in a wreck or your family is in a wreck, and you go to the hospital, only give them the Blue Cross card. Don't give them the claim number. Don't give them your State Farm policy number. Just give them the Blue Cross card. So you don't end up like that young lady who goes in with health insurance and winds up with a big lien. Because that lien stands in front of or between you and the liability carrier when it comes time to collect your just compensation. Make your insurance pay. The reason why you use your Blue Cross is they have highly negotiated rates. They will pay maybe 25, 30 cents on the dollar for medical expenses. When it comes to us and we're trying to handle the subrogation, we can then negotiate that further down. But if you are stuck with a lien for the full amount of the hospital bill for $15,000, $20,000 that Blue Cross might have paid $5,000 for, you can see how the ultimate loser is the victim. So your priority has to be to use your health insurance, use your medical payments coverage where your health insurance has gaps, and as a last resort, use what cash you have, but make it last.
That sounds good, but if you're going to the hospital, you've been in a wreck, you're probably agitated, you might be hurt, or it's your child that's hurt, how do you say those things to the hospital admissions person, administrator, whatever, and say, no, I don't care to give you that policy, just use this because by law I know you have to?
Now, here's my Blue Cross card.
And they're going to accept that?
They have to accept that.
By law?
Yes.
Okay, so that's
They have
our
a
backup.
contract with Blue Cross to accept your Blue Cross benefits.
But if you don't have Blue Cross, it's something.
Aetna, United Healthcare.
Okay, it doesn't matter which one it is.
Right. Well, there are some off-the-wall health carriers that aren't really major health carriers that don't have those negotiated rates, but the hospital is still obliged to submit those claims. Your liability coverage and your MedPay coverage are not first-party coverage. They are not the priority coverage. They are secondary. I don't have a whole lot of time left. I think I have covered the high points. I will tell you that here in the handout, one of the reasons why we tell people don't ever deal with an insurance company on your own, this is an example of something that actually was intended to go to our client but got sent to us by mistake by our good friends at Allstate, with whom you're in good hands, or from whom you can expect mayhem. And they're explaining that if we'll just give them this information, they'll plug it into their Colossus program and they'll figure out what your claim is worth. They want you to do that because you're going to tell them, a month after the wreck, well, I've had $2,000 worth of medical expenses, and you don't know that that back injury is going to be chronic, and 6 months from now you're going to be at the neurosurgeon, but you will have put a price tag on this for their benefit. Never give the insurance company a recorded statement, and certainly never cooperate with Colossus. They are certainly not your friends. So my time is up, and I appreciate your patience, and I'll be happy to answer questions after we're done, but I think I'm supposed to sign off.